anti-Russian intelligence.
Good evening, everyone. Hi. Can you hear me? Good. My name's Edgar Dobie. I'm the executive director here at Arena Stage, and I like to think I've got the best job in the world. And one of the reasons is that we get to introduce new programs and new ideas like we are with Arena's Forum, Civil Dialogue. We asked the question whether that is actually possible in this day and age. And it all started with an across-the-table lunch with Amitai Etzioni, who's if this were a play, he would be our playwright. He would also be our director. This is all his conception. It fell on really welcome ears with us here at Arena Stage because we like to think that we're in the empathy business. One of our trustees asks us at every board meeting, what's your business? Well, I think building empathy is one of them, and writers and stories that are interpreted. We have a number of core values around here, and top of that list is learning from the culture of the rehearsal hall. And in a rehearsal hall, you are meant to be open to new ideas. You are meant to be prepared to take risks. You're meant to be generous and be prepared to step into another character's shoes and to work collaboratively on telling a story. So it seemed to be the idea that we get together and we have some conversation starters, and then we engage in a very civil way in looking at an opposite point of view or another's point of view. Seems to me a really natural fit for us here at Arena Stage. So this is the first in the Arena Stage forums. We're test driving the idea. We have 2 more that are scheduled. That information is in the back of your program here. But it's meaningful to me that we're able to do this on Monday nights. Amitai said Monday nights you're always, there's no performances, so we should light the place up. Well, I'm hoping that we light the place up on Monday nights on many, many occasions around such an important purpose as engaging in a civil dialogue around difficult issues. So I actually feel that Amitai really doesn't need any introduction. His a very brief resume is there in the program. I just want to say that I feel like I've made a new best friend. I certainly admire the fact that you have the generosity of spirit to share your communitarian and your humanitarian ways with us, and the fact that you have assembled such a wonderful group to engage in this discussion. And he must be a bit of a prophet as well, because who knew that the topic for tonight would be so relevant. I know you wanted to pick with something that maybe wasn't so hot and controversial, but didn't work out that way. Oh, you did? Okay, you did. So let me get out of the way. Please welcome my new dear friend, Amitai Etzioni. Thank you.
Edgar, thank you very, very much indeed. It's been a true joy working with you. From that luncheon we had, the whole idea was a long sentence. Edgar and his staff turned it into a three-dimensional series of events with complete easy working together. And it's also an opportunity for me to thank to the arena staff. There's a lot more work goes into an event like this that meets the eye, and to the Institute of Communitarian Policy Studies, to the dialogue starters who are all extremely in demand and busy people who gave us this evening, and for all of you for joining our first dialogue. I'd like to also say, Edgar, we met our first marker because this evening we're going to be on C-SPAN, which means that our conversation is going to reach way beyond this room. We are hoping to model that people who come from different backgrounds, we have people who worked for the government, we have people who worked for the ACLU, we have people from the private sector, we have people from academia, we have liberals, and we have somebody who's not a liberal. And so we have a rich variety of viewpoints, but I'm quite confident that we're going to have, and with you, a very civil dialogue. The theater, for me, is kind of a magical place where you leave the world in which you live, a normal world, behind, and for 2 hours you can dance with the king and I in Thailand, or serve on the jury in Arthur Miller's play of the witches. And tonight, maybe we can leave behind the world of polarization and confrontation and anger, and enter this magical world of dialogue. I just want to add one more sentence, and then I'll get out of the way. The way I see it, what's happening out there is we borrowed from the court system the advocacy model and employed for discussion of public policy and intellectual issues. The way I see it as a non-lawyer, in the court there are only two sides. Very rarely we allow a third or fourth side. That's already polarization. And each side presents in the most stark, extreme, one-sided, emotional way their position. So one side will say the defendant is the nicest person alive, he has a dog, he called his mother every Christmas and so on. And the other side will say he's the most awful person, he doesn't have a cat, and didn't say hi to his father. And everybody, and out of that clash of two one-sided positions, justice and truth are supposed to arise. I'm not sure it works perfectly in the court system, but I'm sure it's not working well in the court of public policy, where one side says privacy is dead or being killed, the government is under every bed and listen to every phone call, and Alexa's recording your dinner conversation. And on the other side, we hear that the corporations are building a safe haven for terrorists, which don't allow the government access even when the court order. And out of this extreme, again, some kind of reasonable position should arise. I think a starting point for a good conversation is to assume that we have at least two major considerations. We clearly have inalienable rights, privacy very high on that list. And we clearly have concern for the common good, for public safety, for homeland protection, for public health. To some degree, they can be reconciled, but they do come into tension. And a good conversation for me starts by not assuming that one of them is going to trump the others and make always wait, but that we'll have to start ask a question, as the court in effect often do. When do we yield, and which one, and how we minimize the conflict? This is, I see, this one of the subjects of tonight's conversation. We want to ask our panelists, are we tilting too far in the direction of security, surveillance, and business? Or are we allowing our concern for privacy and hyper encryption to not allow the government to do its job. Where are we and where should we be going? So we're going to start, the bios for everybody are in your programs. We're not going to repeat them. And we're going to start with you, Gabriel.
Great, thank you so much. Thank you, Professor Etzioni, and thanks to Arena Stage for holding this crucial discussion. So I'm going to be a good lawyer, and I'm going to answer the question with a question here. The question that's presented is, is the balance appropriate between surveillance and privacy? And I'll push back a little bit on that. I think balance is perhaps the wrong word. Our system of government is one that's based around, I think, an agreement that we all have, that the best way to do things is where we have ambition checking ambition. This is the old joke. I used to work at the ACLU. I currently work at Reporters Committee for Freedom of the Press, and there was the one time that an ACLU attorney was on Saturday Night Live, they kept saying checks and balances, checks and balances. That's exactly right, and it's what I think we're all striving to look for, is to have hard and fast rules that ensure that to the greatest extent possible, law enforcement and the domestic activities of our military and intelligence services are focusing on individuals and circumstances where there's some indication of wrongdoing. And the search warrant is the basic example of that. It says that you can't really do anything unless you can articulate in a clear way with specific facts that what you're trying to do is based upon some predication, that it's based upon some real suspicion that what you're going out to do is going to find something wrong. And again, the issue isn't, and you mentioned the word reconcile. I mean, I think in many ways it is reconciliation. We're not trying to balance surveillance and privacy. We're trying to find ways where you have effective law enforcement, but you also respect these primordial principles, these first principles that underpin our free society. So I wanted to make two specific points. You asked us to answer a specific question, which is how can we make things better? And I think in two ways, the answer, I think there are two specific things that came to mind when I was trying to think about that. One is, if I were the king of the world, and I don't want to get wonky, but I would do a better job of we do a better job of establishing policy and legislation that's almost technology agnostic. And what I mean by that is the political system tends to focus on the state of the art at a particular time. Email is a good example of that. If you look at police procedurals, most people think that you would need a warrant to wiretap a phone, which you do, and that you would need a warrant to search emails and seize an email, which you actually don't in some cases. And the reason for that is because Congress, when they were legislating on when you need, on what's required for law enforcement to access email, Congress was looking at a system where it was extremely expensive to store emails in the cloud, the proto-cloud at that time. You were talking about in the tens of thousands of dollars for a gigabyte of information, whereas now that the cost of that is in cents. So the notion of somebody having their entire decade's worth of Gmail sitting up there in a remote server, it didn't occur, or it wasn't front of mind for lawmakers when they were doing that. And as a result, we have a system that doesn't protect things the way that I think most of us would agree that they should be protected. And that has real world effects on the second point that I was going to make, which is that when we're talking about reconciling surveillance and privacy, we need to be approaching it from a common frame of reference. And in many cases, we're not, because we just don't know what's happening. And we at Reporters Committee, we just had a case where this actually happened, again in the email context, where a judge effectively said, you have a First Amendment right to look at the application materials for physical search warrants. But because an email warrant isn't really a warrant, you don't have a First Amendment right to look at the application materials for electronic communication search warrants. So this is a case where the public quest to understand and to define that common frame of reference that can allow us to appropriately reconcile surveillance and privacy is being stymied by this lack of technological agnosticism. That cuts many different ways, but it's a concrete example of how I think, as you mentioned, we can be looking at ways to improve our policy and lawmaking. So I'll leave it at that. I look forward to questions.
Great. Thank you very much, and thank you, Professor, for moderating this, and thank you to you all and to Arena Stage. I'm impressed that there are so many folks here this evening. I couldn't get my own high school-age son to come down here to watch, and so I'm really. I hope maybe he's watching C-SPAN, but I think he's probably playing video games right now. So. So look, this is a really important set of topics, and I know that you, Professor, have dedicated your scholarship to this question of a balance between the common good and individual rights. And in my experience, those two things often are in tension, and I don't think there's any subject that really where that tension is more pronounced than in the area of government surveillance. My own career was mainly in the government. 20 plus years, most of that time as a prosecutor here in Washington, as a federal prosecutor, and then several years in the intelligence community, including at the National Security Agency, where I was general counsel. So I come at these issues largely from that security perspective and from the government perspective. But let me just make really three brief comments in thinking about this, I think help at least frame the issues from my perspective. And the first of those observations really is that this is not a new debate. It feels new at times because it's very salient in today's current environment, but it really goes back to the founding of our country. The imperative to protect the common good and individual rights is embodied in the preamble to the Constitution, which speaks of the necessity of providing for the common defense on one hand, and the importance of securing the blessings of liberty on the other hand. So this goes back to our founding document. And in fact, of course, the founders spoke of this being an ongoing process when they talked about the importance or the effort to create a more perfect union, not stating that this was an end state in and of itself, but rather a process or a journey that we're on together as a nation. As a constitutional matter, and there's a bunch of lawyers here, it's the Fourth Amendment that really captures this tension when it comes to government surveillance. And there, the important concept is reasonableness. That's the touchstone of the Fourth Amendment, as the Supreme Court has said. So what's frustrating, I think, is what is reasonableness? And we've had to become comfortable as lawyers and as citizens with the idea that that's a dynamic concept, that's fluid. That I agree with you, Gabe. It tends to be challenged by changes in technology. But I think the main point there that I'm trying to make right off the top is this debate has been going on since our founding. What is reasonable when it comes to government surveillance? The second point that I would make is that there are no absolutes in this discussion. This idea of reasonableness, it really embodies the idea that this is a balance. When it comes to privacy, there's no such thing as an absolute zone of privacy. Ben Franklin understood that his diary could be subject to being seized and searched by the local constable as long as that constable had followed the law and obtained the necessary judicial approval for that search or was otherwise subject to the rule of law. So there's no such thing in our country as an absolute zone of privacy. Similarly, there's no such thing as an absolute right to conduct surveillance. In fact, surveillance has always been subject to the rule of law. And that's true, particularly with respect to law enforcement and the idea of getting a warrant to search a house. But it's also true going at least back to the 1970s and the Church Committee when it comes to national security and the importance of following the rule of law and having effective oversight over the effort to conduct surveillance for national security. So no absolutes, there's no zone of absolute privacy, and there's no absolute right to conduct surveillance. It's always subject to the rule of law. And then third, in your question, Professor, is have we tilted too far? I'm going to say I think we've gotten this about right. I actually think the balance is about where it should be. In the criminal context, we've certainly struggled to adapt to new technologies when it comes to what's reasonable and under what circumstances a warrant will be issued. But I think the Fourth Amendment has held up to the test of time. And then really importantly, I think in the national security context, when it comes to, for example, the Foreign Intelligence Surveillance Act, FISA, we just had this debate about the renewal of one of the key pieces of that act, post-Snowden, post the debate around the revelations that Snowden had made about that law, and it was effectively, that the law was effectively extended for several more years after a lengthy debate. And I think that extension, without really any significant changes to the law, reflects the will of the people, and the notion that Congress basically has determined, based on the will of the people, that we've got that balance about right when it comes to national security. So the last point I'll make very briefly is I do think there's an area where we need to work much harder, and that is on the cooperation between the government and the technology community. I think we've lost some of that cooperation, and that cooperation is going to be critical to solving some of the key challenges we face, including encryption and cybersecurity, because of the innovation that takes place in our technology community and needs to work better with government. So with that, I'll stop, and I really look forward to your questions and the discussion tonight.
How can we balance the values of liberty and security? We can translate the text and original understanding of the Constitution into a technological age, into the age of Facebook and drones and cell phone surveillance and NSA surveillance. What does the text of the Fourth Amendment say? It says the right of the people to be secure in our persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, but no warrant shall issue, but upon probable cause, particularly describing the place to be searched or the person or things to be seized. What does that text mean? Well, for a nonpartisan understanding of the text and original understanding of the Constitution, you must consult this incredible new app, the Interactive Constitution, which is co-hosted by the National Constitution Center in Philadelphia, which I have the honor to head. And this amazing new app brings together the top liberal and conservative scholars in America, nominated by the top liberal and conservative lawyers organizations, the Federalist Society and the American Constitution Society, to describe 1,000 words about what they agree about and then separate 1,000-word statements about what they disagree about. So if you click on the Fourth Amendment, and I want you to download this app, not now because I'm speaking, but after the show, you will find my GW colleague Oren Kerr and Barry Friedman at NYU saying the core meaning of the Fourth Amendment at the time of the framing was to outlaw the general warrants and writs of assistance that sparked the American Revolution. What were those general warrants and writs of assistance? They were engines of tyranny that authorized the king's agents to break into the homes of colonists and citizens and to rummage through their private diaries and papers in search of thought crimes like seditious libel, criticizing the king, or evidence that they hadn't paid the hated Boston tea taxes. When James Otis denounced the writs of assistance, John Adams said, at that moment, the child revolution was born. So liberals and conservatives agree that any electronic search today that resembles the general warrants and writs of assistance is, by definition, unreasonable and unconstitutional and anathema to liberty. So let's take the three questions that we've been asked to decide today. Cell phone surveillance. The Supreme Court is about to decide what may be the most important case about digital privacy of the 21st century. The question in the U.S. v. Carpenter case is, can the government subpoena, that is demand without a particularized warrant, 5 months of our geolocational records? Those are the records that we emit when we walk around, and our cell phones send them to the digital cloud owned by Verizon or Comcast or whatever my cell phone provider is. And by subpoenaing these records, the government reconstructed the movements of a suspected drug dealer and concluded that he was not only, he was not suspected of selling drugs, he was suspected of stealing cell phones. You can't make this case up. He was breaking into Radio Shacks and stealing cell phones. And by reconstructing his cell phone records, the government concluded he was absolutely a cell phone theft, and they prosecuted and convicted him. He objected that there was no valid warrant, particularly describing his records before they were seized, and says that the search was unconstitutional. What will the Supreme Court do? You know, my predictions are as good as yours, but I believe that this court will, by a strong bipartisan majority, hold that the search of our movements in public for a month is unconstitutional and unreasonable. But the justices are likely to diverge on the reasoning. The more conservative justices, led by Justice Neil Gorsuch, based on the oral argument, are likely to focus on the idea that we have property rights in our cell phone records. When we surrender them to the company, we have certain expectations that those records won't be misused without respecting the terms of service. And therefore, in that case, the search is unconstitutional. The more liberal justices may hold that we have an expectation of privacy in the whole of our movements, that when the government can reconstruct everything we do for 5 months in public, it can find the political rallies we attend, the bars we visit, the poems we write, the love letters that we may not send. And we do have an expectation of privacy in those movements, just like those diaries that were seized during the American Revolution. So we'll see, but I think it's inspiring that the Roberts Court is willing, by often unanimous votes, to translate the values of the Fourth Amendment into a world of new technologies. But that raises lots of hard cases that remain. What about NSA surveillance? There, the government is seizing records that some had held in the past. We had no expectation of privacy, and because of this wonky but pernicious doctrine called the third-party doctrine, this holds that when I voluntarily surrender a record to a third party like Verizon, I lose all expectation of privacy in it. And were that to be the case, then in an age when all of our private diaries and records and movements are stored on third-party servers, we would have, as Justice Sotomayor said, no privacy. It's inspiring that once again, conservative justices, as well as liberal ones, were willing to strike down NSA surveillance like the writs of assistance, and they quoted James Otis's final speech. So I think we are, as a society, and the courts are, as courts, doing a noble job translating these values of original understanding into an age of new technologies when the surveillance is ubiquitous and involves so much intrusion on our movements in public that it clearly violates our cognitive liberty or mental privacy. Because the value that the framers were trying to predict was the right to criticize the government, was the right to write anonymous pamphlets, was the right to engage in political dissent, and therefore the First and Fourth Amendment are intimately connected. That leaves one final question, and it's the biggest one, and we're going to talk about it more in the second bit, but what about Facebook? What to do in an age when Mark Zuckerberg has more power over what we think and what we say and who can read it than any king or president or Supreme Court justice? The latest Facebook privacy scandal is the largest of my life as a privacy advocate and observer. And it is striking to see Mark Zuckerberg responding to the public outrage over Facebook's giving of huge amounts of private data to Cambridge Analytica, and that data, which may have been misused, using to send targeted ads not only in the 2016 campaign, but to influence the Brexit vote. Suddenly, citizens are realizing this is like the general warrants. It's not the government that's seizing all of our intimate thoughts and political preferences and trying to suppress our dissent or push us into one camp or another. It is the private sector. And yet the Fourth Amendment says Congress shall make no law. It doesn't say Mark Zuckerberg shall make no law. So the great constitutional challenge that we face as a society is what to do in an age when the powers of the platforms are not regulated by the Constitution, and yet they are exercising the power of constitutional officers. Those answers are not easy, but the fact that Zuckerberg has said that regulations may be necessary, that Europe is about to pass the most significant privacy regulation of recent years, and that even Congress may be moved to act, leads me to hope that perhaps we will have citizens marching in the streets, as they've been doing so effectively recently, on behalf of translating the Fourth Amendment so it protects the same values of privacy when it comes to Facebook as courts are holding that it does for the US government.
If Peter indulges me for a moment, Jeff, I've been looking desperately for a way to keep you on stage a little longer.
I couldn't possibly.
So enjoy your enthusiasm for another minute.
Thank you.
So tell us, if you have your way, and the government will not be able to search our phones and so on, unless a particularized, how much harm will it do to public safety?
What's so remarkable about these cases before the Supreme Court is that in all of them, the government could easily have gotten a warrant. In the GPS case, which was the first case, the Jones case, where the government stuck a GPS device on the bottom of the guy's car, they actually did get a warrant the first time. It just wasn't valid. They were supposed to only search in D.C., and they ended up searching in Maryland. They were supposed to search for 10 days. They searched for 11. So, and this was the Obama administration. This is not a partisan issue. The Obama administration stood up and said, we have no expectation of privacy in public, and therefore no warrant is needed to search this guy for a month. Completely unnecessarily aggressive position for litigation. And once the government said you need to get a warrant before you can search someone with a GPS device, the police said no problem, we were going to do it anyway. And I'm sure that if in this Carpenter case, the courts hold again that you need to get a warrant before you can get 5 months of cell phone records, that won't be any problem either, because if you've got a serious enough crime like the ones that were involved in that case, and enough time to get a warrant, you can get one too. So I think that this is really why Chief Justice Roberts wrote the unanimous opinion in the Riley case, which said that you can't, when you're arresting someone, open someone's phone and search through our emails, because Chief Justice Roberts said a phone is not like a cigarette packet. You can open a cigarette packet because it might have a weapon, but a phone has our emails, and we have an expectation of privacy in our emails. So Amitai, I think I respect your beautiful effort to balance the interests of liberty and security, and Matt, you did such a thoughtful job in talking about that balance. These are cases, these shouldn't be hard cases, and they're not, because they're nearly unanimous. The only hard thing is, and it's an important analytical leap, for the framers you needed physical trespass before you could trigger the Fourth Amendment. And in the 20s, the court said, if there's no physical trespass, you can have wiretap. Courts have struggled analytically to deal with these invasions that are taking place without physical trespass, but it's exciting to see that they're doing it. And although some focus on property and others on expectations of privacy, out of all the polarization in our constitutional law today, this is one area where liberals and conservatives are agreeing.
Well, what an honor to be here and to follow on the eloquence of Jeffrey Rosen talking about the wonky but pernicious doctrine. And just wonderful words. And you should go to Philadelphia and visit the Constitution Center if you haven't done so, which Jeff's the leader of, so that's amazing. So as a moment of indulgence, I'm a first tenor. I love singing. I sing in my temple choir. I never thought I'd get to the arena stage here. So I'm just like... So let me just say that.
Sing it out.
I'm sorry, I have a sore throat. Obviously, I can't sing tonight. It's actually true. I'm going to come back to this individual and community and do it a little bit differently, thinking about the communities of which nation and which community. Because as we'll hear more about from Microsoft and all, a lot of the issues today are things stored in the cloud, where the United States government might want to get it under the Fourth Amendment, but then maybe the British want it, and maybe we trust the British. Maybe India wants it. Maybe China wants it. And it's the same clouds, it's the same emails, and so we're going to have to sort through among all the countries in the world who gets it. So it's not just going to be our one community behind two oceans. It's going to be somehow interacting with the rest of the world. And when we do that, there's a great temptation to think of American exceptionalism. You know, it's our Constitution from 1787. There's the Fourth Amendment, which Jeffrey just gave to us in perfect word-by-word verbatim. But let's think about if we think we're going to share with the rest of the world when England should get access to it or France. So some of these things are, we should have fundamental rights that are protected even if the request comes from other countries. So we might say, for instance, we're only going to share, we're going to have reciprocity with other countries if they have probable cause for warrants. Right? That might seem like the fundamental thing you have to have, probable cause of a crime, or else the government can't do that. And there's been proposals the U.S. should give access to emails held by U.S. companies as long as they have probable cause. Now, it turns out the number of countries in the rest of the world who have probable cause standard to get emails is 0. No one else has that standard. That's a U.S. unusual standard. Well, then you say, well, maybe that's a sort of strange legal word. Maybe we can settle on something else as the bare minimum of what human rights requires. Let's make sure we have a neutral and independent magistrate. That's another part of the Fourth Amendment. Well, except when I took my history of law, it turns out in France they don't do that. They have investigating magistrates that are actually involved in prosecuting and going into it. They don't have somebody independent. So no probable cause. In many, many countries, no independent judge. And now, which community are we going to go to? Can we have absolutely universal rights? Are there principles? Are we just going to say everyone gets to do it themselves? And so defining which community counts is terribly important. So there's going to be some fundamental rights we're going to, I think, want to have in detail. No torture. We can get a lot of people on board for that. We can have some rights before the government sees your emails where we might have a principle, some independent review, some check on the zealous prosecutor. But the exact details of how you do that might be different. But then there's going to be some things where countries will just vary. One state different from another state, one country from another state. And so as we think of independent and community in a world of 200 countries, in a world where the emails are as accessible to everyone else, we have to think through the 200 countries. I'll give you one example from a different debate, the encryption debate that Amitai's also asked us about. We can come up with discussions in the United States of whether Matt at the NSA or whether the FBI should be able to get decryption, should be able to get into our encrypted communications. And in the United States, we might be able to build a really, really complicated and good structure to make sure they never abuse it. Maybe we could hope for that. Once the US requires, or the companies provide, a technical means to open it up, that's a technical means that's open to the Chinese and the Russians. And so as you think about opening it up, do it as long as you would trust the least trusted country in the world to do it. So if you trust Russia and China with access to the decrypted stuff, go ahead. But if you don't, then don't think the US is going to have the magical ability to see this for the community, but think the Chinese and the Russians and everyone else won't. Because we're going to have the same software and the same devices and the same problems. And so on encryption, where I've come out, having written about it for years, is to say, in part because there's 200 countries, some of which I don't trust, I'm not going to let the US have a way to require broken encryption. We're going to have technical means for cybersecurity. And so I come on that side, but then I say something else. And I'll stop here. At that moment, the police say they're going dark. The police say, we can't see the encrypted communications. The bad guys are going to get us. We have no way in. And going dark is an idea that the police can't see anything anymore. And what I've written instead is that actually we're in a golden age of surveillance. We're in a period, and that's what the Facebook story tells us, where we carry a tracking device on us at all times for location. A lot of you grew up in a world where you did not have a tracking device on you. Now you all carry one. You have databases in Facebook and everywhere else. You have cameras of people around you at all times. And so the police actually have enormous resources to find things for the common good. And we're going to live with that and figure out how to put checks and balances on that, in part through Jeffrey's examples of the cases in the Supreme Court. But then beyond that, we shouldn't break the encryption for everyone. We have to have technical security. If we don't do that, business can't do its stuff. We can't do our communications. It will be broken for everyone, and that's a much worse world.
Hi, so I guess I get to play a little bit of cleanup here, maybe. I'll do my best. This is quite a distinguished panel, and I second Peter's motion that folks should go, maybe as a requirement of attending tonight, visit the Constitution Center. It's really, and if you've got children, take your children. If you've got godsons and goddaughters, take them. I think it's a must visit for anyone who cares about these issues and others that are going on today. And certainly, thank you for inviting me to participate tonight. This is such an important discussion, and it's an important discussion to have a dialogue about with civil society and in a civil way, because these are challenging answers that no one entity is going to have the answer for. The courts aren't going to have all the answers. The government's certainly not going to have all the answers. Companies certainly may not have all the answers. And civil liberties groups might not have all the answers either. But collectively, I think the hope is that we can come up with solutions on how best to move forward. And in part, it's been interesting, and Peter and I kind of go back a ways, working on privacy issues generally for 20 years.
20 years, yeah.
So it's been quite a while, and it's been interesting to see the dynamics and how things change over time. There's a big privacy conference going on in Washington, D.C., and I remember when you probably couldn't get 10 people in a room in Washington, D.C. talking about privacy. And now they've got thousands of people that participate from all walks of life, from companies and advocacy organizations and others, from government, talking about privacy and trying to figure out, talking about different issues that are important. But what I've seen develop over time and is really come to be a part of a lot of the discussion today is two things. One, and some of this has already been discussed, the advancements of technology and how the law hasn't kept up, and also the global nature of what we're talking about now. So it's not just the United States laws that companies like Microsoft have to think about, it's the laws of other countries and how these things all mesh together. And how to decide kind of a fundamental importance, at least to our company, and that's how to maintain your customer and consumer trust, how to maintain the trust of governments that you may be engaged with as well. And for us, that goes a little bit to, or a lot to, what are the expectations of our users? How do we stand up for our users, especially when there might not be a rule of law that applies because the law hasn't caught up? For Microsoft, we consider to be privacy a fundamental human right. And because of that, we do certain things internally as far as privacy best practices, privacy by design, all sorts of things. We also challenge the government. And we've done that in a few instances. We've challenged the government when they issue gag orders, in part because when it's, we're entrusted with our customers' information and the government law enforcement wants to come to us. Thank you, Jeff. Wants to come to a company and ask for information, should we be allowed to, in certain cases, not all cases, should we be allowed to tell our customer that the government is seeking data because the customer is in the best position to defend their rights? In this internet age where before, when the customer is holding all their data in file cabinets, which probably isn't the most efficient way to hold data, the government would have to go to that particular business entity and serve them with the papers and get the information that way. In another case, we received a warrant for information. This was about 5 years ago. We received a warrant for information from one of our users' email accounts. When we did our investigation, and we take a look at when we receive these sorts of legal requests for information, or requests for information, we check and see whether or not they're legal requests. Do they comply with the law? And in this particular instance, we said, well, we don't think the law that currently exists, that was written back in 1986, applies to this particular warrant because it's seeking data that is of a foreign national that is residing in one of our data centers in Dublin, Ireland. And so we challenged the case, and the case wound its way through the courts. We lost in the lower cases. We appealed to the Second Circuit, and we won in the Second Circuit. And in part, the court said that this is a situation for Congress to really act on, that they agreed in part that when Congress passed this law in 1986, didn't contemplate the way the world works today. So, in 5 or 6 years ago, that the Congress didn't contemplate this sort of situation where companies are global, information could be held elsewhere. We have U.S. law enforcement seeking to go in and get this information, foreign nationals sitting in a foreign place. Shouldn't that, and one of the positions that we held, was shouldn't that citizen of that country, say Ireland or Germany or France, pick the country, have the expectation that the laws of their country should apply? So that gets a little bit to what Peter was talking about. So we challenged the case. It made its way to the Supreme Court. We'll see what the Supreme Court has to say. But at the same time, also believing in the Second Circuit's view that this is one for not the courts and not any individual company to sort out, but one that Congress, speaking on behalf of the citizens of this country, has to determine what's the best solution moving forward. Again, updating the laws, and in this case, the law that was passed in 1986, to contemplate the current circumstance. In the course of trying to work through kind of how a new law or a revision and a change to the existing law would work to allow U.S. law enforcement to seek this data, we had to come up with or work with Congress to come up with the right legal framework. And so, what we found was, in the way other companies work as well, and we're all facing the same situation, is not only because we're global, where we're getting requests from U.S. law enforcement, we were also getting requests from foreign law enforcement for information that we as a U.S. company may be holding about the citizens of their country as those law enforcement agencies are investigating cases that are happening in their country. And the same law that we didn't think applied in our case provided we called it a blocking statute, prevented U.S. companies from turning over that sort of information to a foreign law enforcement from another country, even if under that country's laws, those requests went through their legal process and were perfectly legitimate. And so how do you kind of fix this going in both ways? And as it turns out, we've worked for a number of years on some legislation that was just passed last week, something called the Cloud Act. It was attached to the omnibus bill that was passed. And it allows two things. One, it allows for U.S. law enforcement to request data that U.S. companies may have, respecting and going through a process, a comity process, looking at the laws of those other countries, having the ability for those countries to object to that request, the ability for companies receiving the data requests to also object to that. Also setting a rule that allows U.S. law enforcement to obtain data from that a company may be holding about U.S. persons, wherever that data may reside. There's a current court decision. It's unfortunate that the codification of this didn't happen, but there is a current legal decision that requires warrant for content that law enforcement continues to follow. At the same time, the law allows for the U.S. government to negotiate treaties with other countries, like the United Kingdom, for instance, to allow for those foreign countries to seek data about their citizens that U.S. companies may be holding, provided that certain things are met, including that they have a good human rights record, that there's some congressional oversight, that they not seek information about U.S. citizens. And so all of this is a kind of a long-winded way of talking about one instance where our company recognized that the existing laws don't mesh with the way the world works today, and the importance that we thought in protecting our users and trying to set a rule of law that hopefully will carry us forward. There are likely other scenarios like this where, like I said, the existing laws just haven't caught up with the changes of technology, and there's going to be, I think, many instances where additional public discussion, debate, back and forth engagement is going to be needed to sort out a good path forward.
That is a completely excellent start for our dialogues. And I have 20 questions I want to ask you, and I will not, and restrain myself with great effort to get our audience in. But I will ask you one question, and that concerns, we heard repeatedly that the golden standard for protecting our privacy is that the government will not allow to search you unless there's specific authorization of the court for specific search. not an exception for trained engineers, but basically that is the golden standard. And the idea behind it that the government should not go fishing in innocent people, only if there is sufficient reason to suspect that a person committed a crime. But what if there are private companies who keep detailed dossiers on 100 million Americans, 15 items per dossier, and sell them to the government? Isn't that a much bigger deal than when we hear about what happened recently in Facebook? Doesn't it make a mockery of the whole idea that the front door is locked, the government cannot go and search, but it can get it from Clear Choice or from Axiom? Now, I need to explain here for a moment what I'm talking about. I think practically all corporations keep information about their clients in order to send them advertising, improve the service, and some of them will sell that information then to others to get some side income on advertising. But there are a very small number of corporations. Clear Choice has been recently acquired, but in its previous and current incarnation. And Axiom, that's their only business. The only business they have is they collect tons and tons of sensitive personal information, but we're including medical information about, in one case, 220 million Americans, in the other case, 78 million Americans. And they have contracts with the FBI, CIA, Internal Revenue Service, and immigrations, and sell that information. So the question is, don't we have to rethink this whole notion that as long as the government needs a warrant, but the private sector can completely circumvent it? How can that be? I mean, let me put it last line. The difference between the FBI having a detailed dossier on 200 million people, innocent people, and Clear Choice have it and give it to the government is one click and one check. There is really no difference. So let's go the other way around. Let's start with Frank and tell us, we're not talking about Microsoft, we're talking about Axiom and Clear Choice. Where do we go from here?
Yeah, so this is one, and as the events over the past few weeks around Facebook as well, this is one where, like I said in my remarks before, we really do need to have a public discussion. I think for some companies, maintaining user trust, where you've got a more direct relationship with your users, consumers, enterprise customers, business customers, certainly doing something that violates that trust would have some probably some fairly significant business impact. And so I think one of the things that I've seen over time is increased public interest in these sorts of topics. And I think that, and Jeff alluded to kind of the marching, in the streets. That may be more optimistic than I think will happen. Nonetheless, I think over time we'll see some calls for some rules, some changes. I think some of what you just talked about, may come as a surprise to a lot of people. And so, as that comes up, what will the ask of our lawmakers be, our regulators be, in terms of doing something, curbing, some practices? And I've seen kind of the pendulum swing between, the days after 9/11, where I'm sure people would say, in the name of public safety, yes, the government should be able to get all this data. It's important to protect us and keep us safe, and that should be priority. And then after the Snowden revelations, we saw the pendulum swing in the other direction, where it's like, okay, wait, do we really want the government to be doing what some of the revelations revealed that the government was doing or trying to do? A great question, and I think as time marches on, we'll see folks working on what the right solution to it is.
So the question is about data brokers and huge amount of commercial information the government can get. That's roughly the question. So I look at it this way. In the European Union, as Jeff mentioned, in May they're going to have a very strict privacy law go into effect, the General Data Protection Regulation. It's pretty easy to pass regulations and directives in the EU. They write a lot of them. In the United States, when it comes to regulating huge, successful companies, we don't pass a lot of laws. It's pretty hard to regulate that. These same proposals have been around since the 1990s, and they haven't passed for internet privacy on these companies. And in my world, we have the US not regulating even when we see pretty bad problems. We see the EU regulating a lot, even more than I think they should. What we haven't had is a good enough imagination of what could be in between. And people haven't really, at the level of legislative craftsmanship that went into the Cloud Act, of the details, and I think that right now, people are starting to say, social networks, what else is going on? And so Congress has a chance to imagine more than they could imagine. There's people on different sides of the political spectrum who aren't happy of what they've seen. But that's going to take active work of imagining where is some regulation of big business that makes sense. And if the answer is zero, then we're going to have businesses collecting everything and doing everything. And if you want to have less than that, then you're going to probably have to have some laws, and we don't know what those laws should be yet.
Just a quick thought, since Peter's absolutely right that the U.S., unlike Europe, is suspicious of global regulation of the private sector, the courts may have to do it in the U.S. And it's remarkable in criminal procedure classes how much time we take trying to figure out when a private citizen is being used as an agent of the government. So there's something called the silver platter doctrine. And when the police go along with a taxidermist who is looking for marijuana, and the real purpose of the taxidermist going into the marijuana guy's house is to find the marijuana, then he's an agent of the government, but when the police officer happens to ask for it, he's not. If the situation is as you described, Amitai, and Clear Choice's business model is to collect data for the specific purpose of giving it to the government, then it wouldn't be a big stretch of the existing doctrine to say that they're effectively acting as if they're government agents and should be regulated accordingly. And the same judges who are willing to say that 24/7 surveillance is like a general warrant might be willing to say that you can't do through the back door what you're not allowed to do through the front door.
Peter, Jeff, just to clarify, I completely see what you're saying. If they act as a government agent, they're not collecting it for the government. They're collecting it to anybody. And then in addition, share with the government, obviously, that's what's happening.
Well, I think I agree with all three of you on this question. I mean, of course, the problem is that so much information is being collected by the private sector that people are, the business model of these companies is to have us exchange our data, to give them our data so that they can sell it, and then they can give us great free services. I mean, we're now seeing an instance where that whole business model, Facebook's business model, is being called into question. Because the way they make money and the way other social media companies and internet-based companies make money is by selling our data. And for that, we have made this bargain that we get this great free service. And the question is, would we be willing to pay for that service in order to have more privacy protection? I mean, I think that's an open question. The other, just quick observation, I mean, I think one of the challenges in this area, I agree with all your points, Jeffrey, about these cases that are going to the Supreme Court. I think the courts are challenged in drawing the lines about at what point giving over data voluntarily to a third party becomes a Fourth Amendment violation when the government gets that information. This is really a job, from my perspective, for Congress. I realize that may be futile in the current environment, but courts are really, they're not very good at coming up with the policies as opposed to implementing the policies that Congress puts into effect. So I think we have sort of a separation of powers issue here too.
And I'll just, I mean, I agree with all that's just been said. I think there's probably three other things that I would note. I mean, one, and as you note, the notion of legislating in this area and directly regulating the private sector collection of information is an extremely difficult proposition. But there's a couple of things that we could conceivably do. One, we should pay attention to how the government is able to get the information that we share with private sector entities. We have in the United States, for instance, in the Privacy Act that was passed in the 1970s, we have done things that try and control how the government uses information that it has. And I think that's an important element to protecting individual freedoms in this new, brave digital age. The second point is one that you just raised, Matt, right? It's the old joke, if it's free, you're the product. That's something I think we all need to internalize. We need to understand what information we're giving over, how it's being collected, and how it's being used. And that leads me to the third point, which is we need to have the tools at our disposal to figure out how much information is being shared, how it's being used. And that's particularly acute when you're talking about the government and using tools like the Freedom of Information Act and state and local sunshine laws. And it's also important for the private sector. This notion that sunshine is the best disinfectant. One of the reasons why it's a good disinfectant is because the chance that there's going to be sunshine puts a check on somebody from doing bad things. So,
well, thank you all very, very much. If there's anybody in the room who doesn't feel completely reassured yet on that issue, let me tell you, you're not alone. Now it's your turn. There are some standing mics there, but I think maybe should we try that? I think this room is small enough. If anybody wants just to speak from wherever they are and raise a question, make a statement. Or
C-SPAN can only hear it if they talk into a mic.
Unfortunately, the light is in my face and can't see anybody. You wave your hand if you want the floor.
Hi everybody, just a quick reminder, Mox News survives solely on your tips and contributions. It's easy to make a contribution or a tip or leave a tip at moxnews.com, or there are clickable links in the text body of this video. It should take the average person, most people, probably less than 2 minutes. Thanks very much for your time and your continued support. Stay cool, Wednesdays. This war is going to end. Till that day.
Unfortunately, the light is in my face and can't see anybody. You wave your hand if you want the floor.
On the left.
Good evening. I think your panel has touched on numerous issues of policy making and the challenges of technology changes. But the question I have deals with somewhat prediction of behavior of individuals who use, or maybe I should say misuse, the technologies to misuse people's personal information. And my question is, do you see a time when, if not through government, maybe through private companies working with government, that we can start having a way for organizations or individuals, I should say, to challenge companies along with government on how the personal information is gathered and used, or in this case, prevented from being misused? So do you see a time in the future when maybe we can start predicting bad behavior as it relates to a business model or an organization gathering information and misusing that information?
Can I take it? So there's actually been another law passed by Congress this year that addresses some of that. Congress has passed some laws when we weren't looking. I might have, it might be called FESTA, F-E-S-T-A, I'm not sure. But there's, here's part of what it's about. Up until now, if you ran an online service and people posted stuff that was bad, the company that was running the online service couldn't get in trouble. They had intermediary protection for that, Section 230 of an old law. And the new law that was passed this year, which I haven't studied in depth, makes it illegal to do certain things. The people who organize this website now can get into trouble, in particular around sex trafficking and other things that all of us are against. One of the things that's happened this week is articles that Craigslist has dropped all its personals. Because, sorry folks, you missed your chance. And that's after decades, because Craigslist said under this new law it could no longer police the personal strictly enough, and Craigslist's own assets are on the line now. Reddit has eliminated a large number of subreddits also for for at least my kids' generation of people who know what Reddit is. So there's been legislation creeping in saying some of this speech is risky enough that Congress is going to say no. State laws are also moving forward in a third area, sometimes called revenge porn. Right? This is a bad thing to do, gentlemen. You should have pictures with your intimate friend, you break up, and then you post pictures of her to the net. Right? That's revenge porn. It's really awful, shouldn't happen. And states are finding ways to write laws to put pressure on companies not to post the revenge porn. So these are all examples of some misuse of these online services where the companies are starting to take the hit for it. And up until now, they didn't have to, and now they're scratching their heads and saying, what are we facing? Because the abusive actions are now starting to get liability on some of the companies.
But this internet intermediary liability is not without cost. So here's the danger. The Europeans have passed this sweeping new law called the right to be forgotten on the internet. It comes from the French droit à l'oubli, or the right of oblivion, which is very, very French. And the idea is, if we were in France right now and someone were tweeting, you know, Jeff is going on too long, he's taking up too much time on the panel or something like that, after the show, I could sue Google and demand that they remove this incredibly embarrassing, although perhaps truthful, offense against my honor. And Google would have to decide whether I'm a public figure and whether your tweet is in the public interest. And if they guess wrong and a privacy commissioner overrules them, they're liable for up to 2% of their annual income, which in Google's case, I was right, something like $70 billion last year per tweet. So this concentrates the mind, and Google has taken down 42% of the takedown requests it's received for truthful and embarrassing information in Europe, including articles about the right to be forgotten itself. So obviously, putting liability on the intermediaries to police truthful but embarrassing or bad but offensive offenses against dignity clashes directly with American notions of free speech. And that's why the section that Peter just mentioned, Section 230 of the Communications Decency Act, which sounds really wonky, is incredibly important and distinguishes America from Europe, because generally we don't ask Facebook and Google to look at content and decide what is embarrassing or what is true or bad and what isn't. And now, in light of all these Facebook revelations, there'll be new pressure, especially in light of fake news, on the platforms to decide what's fake and what isn't. And once again, do we really want the platforms to be deciding truth? So very hard questions. My instinct is not to put that responsibility on the intermediaries and to come up with some other solutions.
Good evening, gentlemen. My name is Dominic, and as you might be able to hear from my accent, I come from Germany. So we had a police state for several decades. Maybe I'm a little bit more sensible to the topic because of this. But I was actually very happy about the point that Mr. Olson made in the end about big corporations, because in my opinion, there's a misunderstanding with the current Facebook, let's call it a scandal. In my opinion, it's not abuse of Facebook and it's not misuse of Facebook data. It is use of Facebook data, what has happened there. And the whole question, or the whole problem that has been raised already in the panel is the for free mentality that we see in the internet. So that it is convenient to get all the services that we want, messaging, email, and so on, for free in exchange of our data. I pay for my email service provider, I pay for my messenger. I'm an economist myself, I'm not an IT specialist. I don't know if they really keep their promise to keep my data safe. But as an economist, I also know there is no free lunch. So basically, if I don't pay them, they have no other choice than basically using, selling, and exploiting my data. What I would be interested in knowing is what can we do, or when will the rest of the population wake up and basically realize there's something going wrong and maybe they have to change their behavior? What can we do in order to incentivize them? Awareness raising campaigns or education, is this enough? Or can we do anything else to make them understand that there is no free lunch and that not only the government or these specialized agencies like Clear Choice are our problems, but also, I'm very sorry, Mr. Torres, also Microsoft, Google, and Facebook.
So when I talked earlier about seeing the progression of privacy through the years, one thing that companies, or challenge companies through the years, is how to make it very transparent to users about what they're doing with their data, how it's being used. And we've gone from, and I've seen this at my company and likely others, where, you know, when I first arrived and you start to read through the privacy policy, and I'm a lawyer, you know, you get to the, 45th page and you kind of go, okay, wait a minute. And then you look at who wrote it, and it's the engineers who are being told, like, we have to explain what you're doing, and it becomes this legalese gobbledygook, which some people appreciate, and it's very important because you want to be very precise, about what's going on and being very descriptive. But then how do you turn that into something very understandable for the average user? And, one example is, hey, if my grandmother couldn't understand this, and we've got to go back to the drawing board. And so companies have worked through the years, and the FTC, our Federal Trade Commission here, took it upon themselves through the years to kind of try to be helpful in providing some guidance into kind of how to explain to users in a very simplistic way what you're doing with their data, how it's being used, what happens downstream, are you selling it to other users, what's going on. Because to get to your point, transparency is going to become even more important. And I think that the revelations that we've seen, and it's been interesting, watching the reaction of some of our policymakers who themselves didn't understand how data is being used, what's being collected about them. So then you do have to make the choice. Do you want the service provided for free in exchange for kind of what's happening? But to make that decision, you've got to understand what's happening and parameters around that. And then if you don't want that, then you have to decide, do I want to pay for the service? And so, again, this is one that I think, people are going to have, we're going to have this discussion. People are going to have to make these value propositions for themselves. And then I think what we'll see is the regulators, either here or in Europe, step in when they think companies are stepping out of bounds. I mean, certainly it's out of bounds if you're saying that you're doing one thing in your privacy statements or the promises that you're making to users, and then you go about doing something else, or if you're misleading about that or being too opaque about that. I think the Federal Trade Commission, and Peter can correct me if I'm wrong, has brought cases, through the years against companies who, might not be misleading, but may kind of be fudging a little bit about what they're doing with people's data.
So just one quick observation, which is this economic bargain, it goes back a long way. People used to have party lines, and you would give up some degree of privacy by participating in a party line on your telephone in order to have very cheap or free telephone service, going back decades. And that's what we're seeing now. I think the question, as an economist, you would appreciate, I think that the idea that it's going to be up to consumers to really drive businesses to offer more transparency around their private and more ease of use of their privacy protections, or consumers will stop using these services. But I think we're a long way from there, and I think all of us who have any interaction with younger people are often shocked at what they're willing to put on their public Facebook or on Instagram or on Snapchat. So maybe privacy is changing for the next generation, and they're willing to give up that amount of privacy for these incredible services.
Can you stick around for a moment? Let's have the benefit of an economist. I think economists talk about asymmetry of information. So to have this transaction you assumed, in which I'm willingly to give up some private information in exchange for a free service, assumes I understand what the other side is going to do with my information. But if they, for instance, sell it to the government, that never occurred to me that when I bought a pair of sneakers from whatever, that end up with the FBI, or when they use information from different sources to divine my medical condition without directly correct information. So wouldn't you not agree that in order for that free economic deal to work, there has to be some symmetry of information?
there clearly has to be, and I think the problem of all digital technologies, it is that people don't really know how to use them properly. I mean, when we talk about privacy, I always discuss it with my friends, and they say, yeah, I've got nothing to hide. And then I ask them, why do you have curtains at your windows? And why do you don't write any intimate information on postcards, but only in letters that you might send to your beloved ones? And then they say, yeah, because I know that somebody else could read it. Yeah? The problem with all these digital information is somebody else can read it and somebody else can see it, but it's so abstract. I mean, there is a computer and there is glass fiber in between us and so on, and you think just the fact that I can't see it and I can't touch it basically puts it in an abstract space and doesn't make us understand that it is that it's actually accessible to a lot of people or to all the people that have the skills and the capacities. And the big problem that I really see is, I think Mr. Olsen or Jeff, you've just mentioned it, the big problem is, why do all these companies like Microsoft and Google and Facebook, why are they so powerful? Because we have made them so powerful. It's that simple. Without the kind of information, without the data, without the privacy that we have given up on a voluntary basis, and that we've given up on a monopoly basis to very few players in the market, basically they wouldn't be able to create and establish and analyze all these profiles that they're able to take advantage from now.
Thank you.
Hi, I'm Ruth Holder. I've spent the last 25 years or so in telecommunications law since before the passage of the 96 Telecom Act. One of the provisions in the 96 Act was the strict protection of consumer proprietary network information, CP&I. When Mr. Rosen was speaking about the I guess, cell phone thief who was tracked for, what, 5 weeks through Verizon, and someone else talked about the Snowden revelations, which in my understanding was something like this giant data room where everything that went across AT&T and Verizon networks was being listened to, and whether it was US or foreign speakers, it was all listened to, and then supposedly the government was going to decide what they could or could not use. I'm wondering why were those things not protected by the prohibition against sharing CP&I with anyone other than the customer itself?
I could play lawyer on that, I guess. I've worked on, I think, all the things you mentioned. So the Snowden revelations, one set of them, and there were previous lawsuits that the Electronic Frontier Foundation brought about a San Francisco switch. I think people now call that part of the upstream program of the NSA. The upstream program would be a lot of stuff's coming across the system, and the NSA is authorized by a federal judge under a set of rules under Section 702. The FISA court, yeah, federal judge, lifetime tenure, confirmed by the Senate, real judge, you know. Anyway, the point there is that there's been authorization for specific identifiers like this email address. And so 1,000 or 1 million or 10 million things go through, and only one of them has that email address. Only that one is allowed to go into the NSA storage. Now, you could say maybe they're doing that and maybe they're breaking the rules. My view, having worked on it, is that's what they do. And so that was reapproved by Congress this year, that approach. So that's not a secret anymore. That was what was Congress approved. In terms of CP&I, the 1996 Telecom Act and the rules for phone companies, that had to do with the phone companies for commercial use selling data about people's phone usage. So under a court directive for FISA or a court directive for Verizon for cell phone stuff, a judge has said, we are the government, we are giving you the right warrant, and CP&I doesn't stop that. So CP&I is the phone company is not supposed to use your data for the company's own purposes, but it doesn't stop law enforcement or national security if they've shown a judge that they have the right to see it.
Good evening. I don't want to derail the discussion too much, because my question doesn't really relate to the social media platforms or I think the kind of technical aspects of a lot of cybersecurity, but it does touch on the broader elements of security versus privacy. And I was curious because it seems some of you certainly have experience with medical safeguarding medical information, and that's been referenced in your comments about its sale. How do you respond to the current debate over the right to purchase firearms? Because I know some people say that, and I've, you know, to be honest, I would probably say I'm one of them. If someone wants to purchase a firearm, it's a relevant matter what their medical history is and what their psychiatric history is. But as the matter stands today, that kind of information isn't available for state or federal background checks. So I'm curious to know what your thoughts would be on that subject within the parameters of privacy versus security.
It's a perfectly legitimate and a very timely question. Before I turn it over to the panel, let me just mention one thing that most of you may be familiar with, but maybe one or two are not. You used the term medical information. The law really does not protect the privacy of medical information. It tells certain entities, like doctors and clinics and hospitals, that they cannot divulge medical information. But if you, for instance, use any of those many apps to check on your heart rhythm or your status of any other medical condition, Fitted is perfectly happy and free to sell it. So it's important to understand that the law differentiates between a wish to protect the privacy of medical information as distinct from banning actually a rather small set of units from sharing information. But the question stands.
It's a wonderful and important question. From the constitutional standpoint, let me recommend the nonpartisan interactive constitution, which reminds us that if there were to be proposals to allow the sharing of medical information as part of background checks, the Second Amendment would not prohibit it. The neutral explainer on the Second Amendment, which is so valuable to have Nelson Lund and Adam Winkler, the liberal and conservative people on the Second Amendment, agreeing that the core historical purpose of the Second Amendment was to prevent an overweening tyrannical federal government from disarming citizens organized in state militias from defending their own liberty, not a debate about whether it's an individual or collective right. And then both scholars note that in the Heller decision, the Supreme Court, in Justice Scalia's majority opinion, explicitly said that all sorts of reasonable regulations, including restrictions on people who are mentally ill from buying guns and so forth, would be reasonable and consistent with the First Amendment. So if we fail to pass the regulation you propose, it's not the Constitution's fault, it's because Congress and the states don't want to pass it. What's so interesting about your suggestion is you could imagine a system that balanced the obvious use of this data for security purposes with the legitimate privacy concerns of individuals and of gun owners. Second Amendment advocates are understandably concerned that there not be over-inclusive do not buy lists that you can't get off of, but you could imagine a list that's properly vetted that you can appeal to get off of and also would be queried anonymously and not reveal any individual's actual data unless they were found to have a serious mental illness and were put on a do not buy list or something like that. So it would all turn on the technologies of anonymity that were designed and the regulations that enforce the legitimacy of the database and so forth. And you could, in theory, design this great system, and Congress could, in theory, pass it, but that's a very theoretical possibility in the current environment.
Good evening. Thank you very much. Can you hear me? Okay. This is very interesting. Thank you very much for sharing your opinions and experience. Today at work, I had, coincidentally, the opportunity to review the privacy policy for the messaging app that we use at work. And I noted that they are about to release a new version of that. So they're currently revising that. They have the new policy and the old policy up there. They have done a better job of being clear or being less legalese. However, they're not any more clear in what it actually means. They don't really define the terms. They don't really say what other means or what third parties means or what other uses could be. And so with zero legal training, and not a lot of time to study this in depth, what resources are available for people like me who would like to understand more, don't really want to hire a lawyer to go through this stuff, don't really want to spend hours poring over these terms? Are there consumers union offices or campaigns working on this? I heard something about the Electronic Frontier Foundation. Can you share with us some resources where we can go for more information, and who can you recommend as credible advocates for this?
Sure. Yeah, I absolutely. I mean, so you mentioned EFF. EFF is a great one. A number of other organizations in the space of the Center for Democracy and Technology, the ACLU. I mean, you can also, you know, I mean, one of the issues here too is that if you don't understand it, you don't understand it as just a regular reader, you know, that in and of itself is a problem. And there has absolutely been a shift on the part of technology providers to make their material as understandable as possible. And so if you're reading a privacy policy or terms of service on a website and you can't make heads or tails of it, you know, that in and of itself is a red flag.
Just very brief. So Consumers Union has actually announced a major project. They're going to start trying to systematically rate products for security and for privacy. So along with, and by the way, their car issue will matter because God knows what's being collected in your car with the electronic stuff going forward. But that's an effort for ordinary consumers of all sorts to be able to have somewhere to look to try to figure out which of these is better to use.
And then if you're just looking for general information, I would recommend the FTC's website. I'm not sure exactly where, but just general information because, like I said, they've done work over the years around how to make privacy policies more understandable and readable. And also, Chris Hufnagel, who's a professor at University of California, Berkeley, I think, through the years has also tried to digest kind of companies' privacy policies and how to kind of read them.
Can I make one quick other suggestion? Because it just occurs to me, as you made your point, Peter, this is an area where security and privacy come together. When you think about cybersecurity and what happens when companies have your information and they don't properly protect it, and you think about, for example, about the Equifax breach, which affected every single person in this room, almost certainly, our information, which we never said to Equifax was okay to hold and to sell. They had, and it was stolen. And so here's an area where security and privacy are completely in line, because the better security that they are providing to protect that data, the better our privacy is protected from that information being lost or stolen.
Okay, thank you. Our friend from Microsoft over here mentioned the Cloud Act earlier, and I was curious of everybody's take on the Cloud Act, because in terms of whether it was a good thing for the public.
Well, you like more what you're saying. For those of us who are not completely familiar.
So I'm not super familiar with the Cloud Act, but I know the Electronic Frontier EFF and some other groups were adamantly opposed to the Cloud Act, and it seemed like it was passed kind of in a, it would kind of circumvent the traditional way by going through the omnibus. So I was curious if anybody had any input on the Cloud Act and the impact it will have on consumers.
Well, so the Cloud Act does two basic things. One, there, as panelists have mentioned, there's a Supreme Court case, Microsoft, commonly called Microsoft v. Ireland. Microsoft is challenging a probable cause warrant that is seeking records that are they're seeking data that's physically stored overseas. That case, the Microsoft's argument in that case is effectively that the law that permits an email warrant does not apply extraterritorially. The Cloud Act answers that question in the affirmative. It says that an email provider must disclose to the government those emails regardless of where the data is, whether it's here in the United States or whether it's overseas. It also has a second part which would deal with what are called mutual legal assistance treaties. So if another country wants law enforcement assistance here, or if we want law enforcement assistance abroad, there's a system right now, mutual legal assistance treaties, where you go through, where in many cases, the other country would come here, the Department of Justice would go and get a warrant, and then get the information, send it overseas. This would create a system where the Department of Justice, with the concurrence of the State Department, could on its own enter into agreements with another country where they say that that other country has sufficient procedural protections to protect privacy enough where we can have a reciprocal agreement where they can get stuff here and we can get stuff there. And in terms of positions on the law itself, as you say, it was included in the omnibus. I think it would have stood from I think it would have benefited from additional debate and additional publicity. And I think everybody agrees that there are concerns in the. I think even those who support it and support it for very good reasons, given the alternative, agree that it has certain parts that I think we need to keep an eye on that might be problematic from a privacy perspective.
Can I just one sentence? So I've spent a lot of the last 3 years working on these issues. We have a project at Georgia Tech called the Cross-Border Access to Data Project, when governments try to get access to data in other countries. So we have a whole webpage on it and hundreds of great pages to read about it. I'd say based on that research that I think it does a surprisingly good job compared to what might have happened. But undoubtedly, as Gabe said, there's things you could polish. If we didn't fix it, we were going to have all sorts of a mess. And you always have to judge whether this imperfect legislation is better than the mess we would have had otherwise. But a lot of the civil liberties groups have been very concerned about it. I've written about why I think all things considered it's actually good for privacy and civil liberties. But people have very sharp disagreements on that.
I want to go back to basics for a moment. And we heard kind of two positions from the panel. On one hand, the third-party doctrine, the American idea, that once you release information to another party, they can do with it what they want. By the way, I'm not exactly sure that's the only interpretation of the third-party doctrine. Maybe it says the government doesn't necessarily mean that. But let's walk around this fine print here and say basically it's a conception. Once you release it, it's gone, okay? And in contrast, we heard this idea that Europeans say, no, you own the information, you gave it to somebody. If they want to use it for second use or give it to anybody else, they have to go back and get your permission. So these are kind of the two bookends, two extremes of a continuum. Now, when I looked a little closer to European Union position, actually European, it's not necessarily European Union, position, it gets a little more intricate. So first of all, if indeed every time a commercial firm will want to use information you release to somebody and ask your permission, you'll be sitting the whole day at your computer saying yes or no, because on average day, information about you is used, let's say, 700 times, and I don't think most Europeans do that. Second, if you read the law, as I did, it exempts one area after the other. They don't have to do this for defense. They don't have to do this for research. They don't have to do it for commerce. So pretty soon, when it looks like such a wonderful idealistic solution, that you own the data and nobody will touch it unless you give permission. And then you add one last thing. In those areas in which the law apply, the Europeans have something which they call a compliance gap. Means they don't enforce the law. So every time I went to Europe so far, in an evening like this, and I said, is anybody in this room has been ever asked by anybody for permission for second use of the information? Would you raise your hand? I've seen one hand rise, and it said Amazon did. So let me get back to the panel. And is the European law anywhere near as idealistic as it sounds? And is it practical if it is? And where do we find a new base somewhere between the third-party doctrine and this notion that we own the data and anybody touches it needs to get written permission?
Neither approach seems satisfying. The idea that once we surrender information to a third party, we lose all expectation of privacy, and it, as Justice Sotomayor said, would mean in the age of the cloud, we have no privacy. While the European approach that data disclosed to a third party may be disclosed to someone else with consent risks the danger that we might give away our privacy in exchange for a toaster. Or we might just click away and not read the policies, and then we can't get it back. For me, the alternative to the third-party doctrine is answered by the immortal question, WWBD, what would Brandeis do? Justice Louis Brandeis wrote the greatest privacy dissent of the 20th century. If you want some really inspiring homework, read his dissenting opinion in the Olmsted case. And he says the proper question is the government invasion an unreasonable intrusion on our security and safety? Does it reveal unexpressed thoughts, sensations, and emotions? And if it does, then it's unreasonable and impermissible even with a warrant. That case involved wiretapping, and he said that wiretapping is so invasive because you can hear the conversations of people on both ends of the telephone conversation that it was unreasonable even with a warrant unless the crime was very severe and the suspicion was very intense. So that is the practical question we need to ask. What does it mean to have cognitive liberty and freedom of our thoughts, sensations, and emotions in a free society? And when the search is so vast that it invades that privacy, it's inherently unreasonable with or without consent.
I got so excited about this discussion that I didn't realize we overrun the time. And so at this point, all is left for us to do is thank the panel for a wonderful discussion. Thank you. Thank you all for joining us, and I hope to see you on April 23rd, when we're going to have a discussion on what we as a nation owe other people. We're going to have Wei Nu, who is flying in from Burma. She's a Rohingya, to tell us about the plight of the Rohingya and what she thinks we should do for them. But we're going to discuss the more general question. Do we owe foreign aid to everybody? Do we have to engage in peacekeeping? Why did we do no more Kosovos? Why did we not stop the war in Syria? Thank you for coming. Hope to see you soon.
Coming up tonight on